Well, good afternoon, everybody. It's great to have a chat with Becca and Millbilly, along with Pete yesterday evening. Feeling a bit better now. Took the dog on another long walk this morning, and even did, I suppose, what could be classed as a little bit of a childish thing. Rather than walking on one side of the riverbank or the other on the way back, we decided to walk through the water for about 60 yards, which got my feet absolutely soaking wet, my shoes and socks, but never mind, they're drying now very nicely. But it was a bit squelchy on the way back home. Never mind. Felt a lot better for it. So we got as far as the dude about to talk about documents. So we'll just jump straight in to the second part, to the end of this Erekose presentation. Let me share screen. Share sound would help. Share that. Click on that. Move me out of the way up there. He's got a bit of a grin on his face there, hasn't he? Come on, let's have a listen, see what he has to say.
We're going to move into the first set of documents. Oh, by the way, you may have noticed today that I am dressed up looking a little spiffy here. My buddy Paul Capaldi sent me this from Scotland. So it was very nice of him, and I just had to wear it and say, thanks, Paul. Paul also does some YouTube videos over on his channel. I don't know if any of you know that. You can go check him out. I'll leave a link to one of his videos also below so that you can go over there and check that out. So here we go. We're going to go ahead and move into the documents. This first one, folks, is a little bit... there's a lot of that I just couldn't leave out. So there's a little bit of text coming up here, but I'll be reading it for you. So you can even put your phone down and just listen to me tell you what's there. Because trust me, you know the documents are in my videos. You know I'm not going to be BSing you. So anyways, here we go. On November 11th, 2017, undersigned counsel Kathleen Zellner had a meeting with Mr. Avery's trial attorneys Jerome Buting and Dean Strang. One of the purposes of this meeting was to determine whether certain evidence was disclosed to Mr. Avery's trial attorneys before his trial. During the meeting, it was discovered that, in fact, the state failed to disclose material exculpatory evidence related to Bobby Dassey's status as a potential suspect. Specifically, the state failed to disclose the report of a forensic analysis performed on a computer to which Bobby Dassey had access prior to and after Teresa Halbach was murdered. Such evidence would have strengthened Mr. Avery's Denny motion, which was pending at the time, and the computer forensics report should have been disclosed. Disclosure of the computer forensics report would have enabled Mr. Buting to meet the Denny standard by establishing a motive of sexual assault for the murder of Miss Halbach and to introduce Bobby Dassey as the alternate suspect to the jury. Mr. Buting's affidavit is attached in the second supplement. Mr. Buting states that when Ken Kratz tendered discovery to Mr. Avery's defense, Mr. Kratz itemized the discovery in cover letters which accompanied the disclosure of the documents. By way of correspondence dated December 14th, 2006, Mr. Kratz disclosed a large batch of discovery. Included in the discovery was a report from Special Agent Tom Fassbender entitled Examination of Brendan Dassey Computer. The report number was DCI report number blah 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 blah, and the report was dated December 7th of 2006. As described in Special Agent Tom Fassbender's report, the state seized a computer from the Dassey residence on April 21st of 2006. The report indicates that the computer was then transferred to Detective Mike Veely at the Grand Chute Police Department for forensic examination. Per Special Agent Fassbender's report, Detective Veely returned the computer to Special Agent Fassbender on May 11th, 2006. The report further states that a subsequent date, Special Agent Fassbender received from Detective Veely a CD entitled Dassey's Computer Final Report, Investigative Copy. The report also states that the CD contained information on the website and images from the hard drive. And Mr. Buting avers in his affidavit that neither of the above referenced CD or the Detective Veely's investigative report were turned over in discovery. The December 14, 2006 letter from Mr. Kratz likewise confirms by omission that neither document was disclosed to the defense in the batch of discovery. Mr. Buting likewise notes that Special Agent Fassbender's report indicates he did not book the CD or Detective Veely's report into evidence. Rather, the report states that the disc received from Detective Veely, as well as the hard copy pages of instant message conversation, were maintained in Special Agent Fassbender's possession. Thus, Mr. Buting did not observe the CD entitled Dassey's Computer Final Report Investigative Copy when he reviewed the evidence maintained by the Calumet County Sheriff's Office prior to Mr. Avery's trial. To the best of Mr. Buting's recollection, he never saw the CD entitled Dassey's Computer Final Report Investigative Copy, because he thinks that would have stood out in his mind. It would have caught his attention. Although the state has never disclosed Detective Veely's final report, the report must contain evidence favorable to Mr. Avery, as noted in Mr. Avery's motion for reconsideration. Gary Hunt, a forensic computer expert, has performed an analysis of the Dassey hard drive. Mr. Hunt has further refined his analysis of the Dassey computer to isolate violent images of sexual acts that involve the infliction of physical pain and torture, and an equally disturbing fascination with viewing dead female bodies. Importantly, many of these searches were performed at times when only Bobby Dassey was home during the week from 6:30 to 3:45. All other Dassey family members who lived in the residence were either at school or at work during those hours. However, Scott Taddick was observed driving towards the Dassey residence in his green truck on several occasions during the time period. Mr. Avery never accessed the Dassey computer and did not have the password for the computer. Mr. Avery did not have a key to the Dassey residence, and the residence was locked when no one was home. Mr. Avery only entered the residence with permission of a Dassey family member. Mr. Avery worked during the weekdays from 8 a.m. to 5 p.m. The supplemental affidavit of Stephen Avery is attached and incorporated herein. Mr. Buting describes the significance of the state's concealment of the Detective Veely's final report in his affidavit. At the time the voluminous discovery was tendered on December 14th of 2006, defense counsel was preparing to litigate a Denny motion to introduce evidence of third-party suspects at Mr. Avery's trial. Judge Willis ruled against the defense on this Denny motion because the defense failed to present any evidence of the motive for murder. Had the defense been able to use Detective Veely's report to link Bobby Dassey into violent sexual or deceased body images on the Dassey computer, the defense would have been able to establish sexual assault as the motive for Miss Halbach's murder. So you see what I mean, folks, where they're basically intentionally trying to hide that information from Officer Veely. It's pretty obvious. I mean, why is that the only two pieces of evidence that are held particularly in Tom Fassbender's custody? I mean, what? That's just really odd. Okay, so, pretty clear there was some shenanigans going on there. Let's be real about it, right? So now we're going to move on now to, we're going to go through what Zellner had to say about Bobby and Scott. I'm going to show you some of the list of things, like what the searches on the computer were and stuff. I'm going to show you her list of what about Scott, makes him fit as a suspect. So we're going to go through some things right here that you'll see. She's really kind of being a lot more specific in this particular filing. She's really kind of offering a lot of detail, and really trying to, put a timeline together almost in a sense. So we'll move into that document now, and we'll come on back. Okay, these are some of the searches on the computer. 5 additional searches for terms describing drowned, dead, or deceased female bodies, specifically deceased girls or diseased girls, and rotten. 50 additional searches for terms describing the infliction of violence on females, including fisting and images of females in pain, specifically girls groaning bleep face, fist fuck, girl moaning bleep face, and girl guts. So that was just some of the searches that were happening. See the second supplemental affidavit of Greg McCrary for his take on why this behavior, or why these searches suggest a pattern of behavior. Mr. Avery would be eliminated from all but 15 of the 128 searches as the simple issue as he was arrested on November 9th. Mr. Avery, in his unrebutted affidavit that he never accessed or used the Dassey computer at any time, much less to search for violent images of dead bodies. At the forensic analysis done of Mr. Avery's computer revealed no searches for sexual images and much less violent images and dead bodies. Brendan Dassey would be eliminated from all but 26 of the 128 searches at issue by having been arrested on March 1st of 2006. The state's concealment of the Ville report prejudiced the defense. The report would have provided the defense with the ability to meet the Denny standard, and therefore would have raised reasonable doubt, resulting in Mr. Avery's acquittal. The existence of this new Brady violation undermines confidence in the verdict against Mr. Avery. At a bare minimum, Mr. Avery should be allowed to present this evidence at a significant Brady violation at an evidentiary hearing. Scott Taddick as a potential suspect. Greg McCrary, current post-conviction counsel's police investigation and procedure expert, opines that Mr. Taddick was not thoroughly investigated as a potential suspect by the law enforcement during Miss Halbach's murder investigation, but he should have been for the following reasons. Several incidents of violence against women were reported about Mr. Taddick, one of which resulted in a battery conviction on July 29th of 1997. Mr. Taddick's multiple inconsistent statements severely undermine his credibility at trial. See motion for reconsideration. Mr. Taddick should have been investigated regarding his actions on November 3rd of 2005 in light of the anonymous handwritten note discovered by the Green Bay Post Office and reported to the Green Bay Police Department. Mr. Taddick worked at the Wisconsin Aluminum Foundry at 838 South 16th Street, Manitowoc, Wisconsin. The note specifically referenced a body being burned at 3 a.m. at an aluminum smelter. Mr. Taddick worked the third shift of the Wisconsin Aluminum Foundry. The note, which was never thoroughly investigated by law enforcement, is potentially the great evidentiary value because the note was sent on November 9th of 2005 and it was not disclosed to the public until November 11th of 2005. That Miss Halbach had allegedly been burned in the Avery burn pit. Current post-conviction counsel's investigator James Kirby has confirmed that Mr. Taddick's nickname at work was Skinny, and according to a current employee, many of the shift workers are not totally literate. It is a reasonable inference that a semi-literate employee might have misspelled the word skinny in the note. Mr. Taddick should have been investigated more thoroughly by law enforcement during the Halbach murder investigation. At a minimum, Mr. Taddick should have been asked to provide his DNA and fingerprints so that they could be compared to the crime scene evidence. Mr. Taddick's failure to respond to Kevin Ramlow's text about seeing the RAV4 at the turnabout by the old dam in November of 2005, before the discovery of the Halbach vehicle on the Avery property, is also suspicious. Affidavit of Kevin Ramlow included. His recent telephone call with Mr. Avery demonstrates his knowledge that Miss Halbach had left the Avery property on October 31st of 2005. The telephone call also demonstrates that Mr. Taddick has a violent and uncontrollable temper. Mr. Taddick threatened to physically assault Mr. Avery and even more disturbingly put Mr. Avery in the ground. See the supplemental motion. So, like I said before, those images and the searches on the Dassey computer, combined with the fact that there was actually pictures of Teresa Halbach there, all that together is a cause for concern. Like I said before, if it was just one or two of those things, then you could probably go, well, okay, it's maybe harmless, right? But when it's all three of those things, it's kind of like an on the head sort of situation, nail on the head situation. But, there's obviously different ways to analyze evidence and different ways to assess it. So we'll leave that for the courts. Obviously, just like before, everybody here that she's talking about, the Scott, Bobby, the Brian, anybody else, all innocent until proven guilty. That's the way it is. because if we're mad that Stephen kind of got a raw deal or was given the shaft, we gotta make sure that everybody else that gets attached to this gets their day in court, that gets an honest chance, to provide their defense, that like Stephen Avery has been prevented here. So, which is becoming more and more obvious. Tom Fassbender's personal custody. You got to be kidding me. But anyway, there's also in there talking about Scott Taddock. So I don't know if you guys got that, but they were talking about the nickname Skinny, and on the letter that went to the Green Bay post office and got turned into the Green Bay Police Department. And if you guys will know that's the Sikaki letter. Pretty much everybody who's involved with MAM knows about the Sikaki letter. Now, what Zellner is basically saying here is that, number one, Scott worked the third shift, which is would be at 3 a.m. And she's also saying that a current employee at the aluminum foundry said that it's very common for their employees there to be less than literate. Okay. So what she's basically saying here is that she thinks that maybe the Sikaki letter wasn't supposed to say Sikaki. It was just horrible grammar, horrible handwriting, and that it was actually supposed to say Skinny. Put her in the smelter or whatever, aluminum smelter. So that's what she's kind of going with. I don't know. It looks a little... Not sure that that's true. But it's been a long time since I looked at the Sikaki letter. So obviously I'll be looking at that stuff coming up here real soon, because this obviously isn't going to be the only video about this particular motion, because I think I'm going to do an additional one, possibly two, talking about the attachments, which are interesting. So okay, we're going to go ahead now. I'll move into the last segment, and then we'll come on back. Whether or not an attorney is experienced is not the criterion for determining whether counsel was effective in a particular case. And the fact that an attorney is ineffective in a particular case is not a judgment on the general competency of that lawyer. It is merely a determination that a particular defendant was not appropriately protected in a particular case. As Judge Bazelon has written, ineffectiveness is neither a judgment of the motives or abilities of lawyers, nor an inquiry into culpability. The concern is simply whether the adversary system has functioned properly. The question is not whether the defendant received the assistance of effective counsel, but whether he received the effective assistance of counsel. In applying this standard, judges should recognize that all lawyers will be ineffective some of the time. The task is too difficult and the human animal too fallible to expect otherwise. Bazelon, the realities of Gideon and Argersinger. Current post-conviction counsel has previously alleged that the trial defense counsel was ineffective for their failure to consult with a blood spatter expert who would have opined that Stephen Avery's blood was selectively planted in Miss Halbach's vehicle, and that the rear cargo door blood spatter was the result of Miss Halbach being hit in the head with a mallet or hammer as she lay on the ground next to the driver's side rear wheel of the vehicle, and not, as the state contended, from being tossed into the back of the vehicle. A blood spatter expert would also have prevented the defense from erroneously claiming that 1996 blood vial was the source of Stephen Avery's blood discovered in Miss Halbach's vehicle. Current post-conviction counsel has previously alleged that the trial defense counsel was ineffective for their failure to present a ballistics expert who would have opined that if Miss Halbach were shot through the skull by item FL, there would have been bone fragments embedded in item FL. Okay, so there she talks about ineffective assistance of counsel, and she offers what another judge said about ineffective assistance of counsel, and basically she's establishing that because counsel is ineffective in one case doesn't necessarily mean that counselor or that lawyer themselves are ineffective. It's just that in that one case they were ineffective to help the defendant that they were trying to defend. So they're basically saying there's no real culpability or anything along those lines. It's just sometimes a lawyer falls short because of the complicated nature of the job or because of human failings. It's just something that's going to happen. So it has to be considered. So then it goes on to talk about, now this is one of the things that is a huge big deal for me. Okay, it's and I did a video about it, and it's I'll go ahead and post it below so you guys know what it's talking about. It's the video about the blood spatter, and she brings up the blood spatter here, that because Dean and Jerry didn't bring in a proper blood spatter expert who would have been able to, testify and kind of dissipate some of the illusions that were going on here, particularly where Teresa Halbach was murdered, which was not in the trailer or the garage, which we've all known forever. Well, any of us that have any sense, really, because you can't murder somebody somewhere and just completely not have any trace of it, especially when you use a gun and there's high velocity spatter, and no. So that's one of the most interesting things. She brings up that, so I'll post a link to my blood spatter video below so you can check out what that's all about. And then she brings up the fact that the bullet didn't have bone fragments in it. It had wooden paint fragments or whatever, but it did not have bone fragments in it, and that Dean and Jerry could have brought in experts to testify that the bullet should have bone fragments in it. Well, I don't know exactly how Dean and Jerry might have been able to do that. I don't know if Microtrace was up and running in 2007, but maybe it was. I don't know if it would have been advanced enough in 2007 to be able to detect the minute bone particles. But the point is that they definitely did miss bringing in a blood spatter expert. I totally 100% agree with her on that. They really, really should have done that. That would have helped the case greatly, really, in my opinion, because just look at what her blood spatter expert figured out. I mean, it's my opinion. I am convinced that he found the crime scene, that it was right at the back of her RAV4, wherever it was, which we now have heard from more than one person that she left that yard. She left. So that's where we're at. Zellner's basically coming out guns blazing. She's like, okay, look guys, I'm sitting here trying to go through the process here. I'm trying to let you know there's a lot of evidence to go through here. The state's attorneys have already agreed to more testing. The thing that's funny about that is that Fallon in the state decided to make a deal with her, and so that she could test more things, right? Because in my opinion, I mean, why would they do that, right? Why would they do that? Unless they thought the evidentiary hearing was going to be granted. And unless to my mind, that means Fallon thought that she was going to get her hearing. Whether or not it went beyond that, I think it shows that he thought she was at least going to get that. And the fact that she has now not gotten that, and there now is this agreement between her and Fallon in the state, essentially, that is being prevented from being honored by the decision made by the judge. So it's really interesting here what's going on. But I judge by the fact that Fallon was making agreements with Zellner that he was already assuming that there was going to be an evidentiary hearing. That I think by his own assessment, he figured that by the way that they rule, or by the way that they determine whether evidence meets the standard to grant an evidentiary hearing, he obviously must have looked at that motion and thought there was more than one or two things that would have to be, argued in court. It's my opinion. I may be wrong, but I'm probably right. Because why did he agree to do all that stuff only to have the judge deny it? And I mean, look at what Zellner's saying, that, like I said in one of my videos, that the standard that you have to meet to get an evidentiary hearing isn't super high. It's just you just got to be able to show a few certain factors, a few certain things, the kind of the when, where, what, and whys of why that what you're introducing is important, and if it stands to reason, basically, then then an evidentiary hearing is supposed to be held. So that's where we're at right now. She's given the state one last chance with this today. If she doesn't hear anything by tomorrow, I guess she's pretty much ready to take it over to the appeals court and have the appeals court decide on whether or not to vacate Judge Sukowitz's decision to basically deny Avery and to essentially overrule Judge Willis's previous order that Avery's attorneys and Avery himself would be able to test the evidence. That was something he put in there that I guess he thought was important, which is one good thing that Judge Willis did. So I gotta give it to him. So we gotta see where this is going, but it looks like we're going to appeals court with this. So, could get interesting. That's about it for this video, folks. If you haven't already, please hit subscribe, and we'll see ya. And thank you, Paul.
You're welcome, dude. Oh dear, cracks me up every time. He also got a couple of other ties off me that were quite smart, including the Pink Panther one, and a few other things. And as you can see by his studio, people used to send him all sorts of stuff. Captain Crunch. We've got Australian flag. Actually sent him the American flag and the Scottish flag. I think that would have been Shower and Sunshine. I think that Scotland flag was Shower and Sunshine. I think the Australian flag would have been Penelope Muldoon, and obviously some artwork by Linda. And I have a funny feeling that a little thing in the corner there, I might be wrong, but it could be Becca that made those. What else have we got? We've got obviously stuff from Australia. Well, I really wanted to go over obviously some of the things that he mentions in the video. It's interesting, isn't it? Because to some of us supporting this case, it seems like we're no further forward. We are still waiting on the Court of Appeals now for the third time, to pull the finger out and say to Judge Sukovich, stop messing us about. But it's clear, isn't it, that as soon as Kathleen Zellner was going to get her hands on the RAV4, word obviously got out, and that's when it started getting shut down. Interesting talking about the Sakiki letter. I fear that's going to be one of these mysteries that's going to remain a mystery until Stephen and Brendan are out and the proper perpetrator or perpetrators have been found out, and then the Sakiki letter probably will make perfectly good sense. I think it's important to stress that when it comes to the ineffective assistance of counsel, it would be very easy for any of us to be described as ineffective, given the shenanigans of Ken Kratz and Tom Fassbender. I don't think we need to hold Dean and Jerry too much to account over their performance, which in trying to defend Steve has garnered them a lot of good comments. That's better. It's interesting, isn't it, that not a single blood spatter expert was actually at trial. Nick Stolke is actually a handwriting expert, apparently, and he was the only one that gave any testimony. And even then, Ken Kratz was able to twist his words into being able to say that the blood spatter occurred when Teresa's lifeless body was thrown into the back of the car, as if you could just pick up like a football and just throw it in the back of the car. Yeah, pretty bizarre. Anyway, it's as usual always good to watch and listen to Erekose talking about the case. And yes, we have previously looked at the blood spatter expert. Experts that there was two of them, wasn't there, that were featured in Making a Murderer series 2. The dude often used to talk about the fact that when you look at the blood that's left in the RAV4, the 6 dots, it was like, the one expert said, they don't add up, they're not on the same page, they're not even in the same book. And that was one of the dude's favorite quotes from MAM too. Anyway, I'm going to shoot off, do a bit more work, and we'll catch you all again soon. Take care. Bye for now.